Welcome to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the DeWitt Law Firm at 1-800-DeWitt-Law, that's 1-800-DeWitt-Law, or visit DeWittLaw.com. And if you want to get your legal questions answered on this show, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. We are here every Sunday morning at 10 a.m. talking about Florida's legal issues and how they affect you. My name is Jon Busdecker, and across from me is Moe DeWitt of the DeWitt Law Firm. Good morning, Moe.
Morning, John. How are you doing?
I'm fantastic. I'm always fantastic on Sunday morning. You were on vacation.
Very chipper.
Yeah. Well, I try. You were on vacation recently.
I was. We were, where were we?
Where'd you go?
I was out in Wyoming.
You were in Wyoming. How was that?
It was great. It was really nice, a little bit cooler. Beautiful scenery. Went to Yellowstone.
I feel like anywhere would be cooler than Florida right now.
Just about.
Maybe not, though. It's hot in Arizona right now. 120 degrees there.
Yeah, we're almost there. Not quite, though.
It just feels like 120 degrees here.
Exactly.
It's the dry heat, and they say in Arizona.
Yeah, it's very wet heat here.
Yeah. I'm more of a wet heat person, I guess.
Yeah, whatever that means.
So, Moe, before we get into it, I want to mention the Just Call Moe Comedy Jam. It's coming up.
Yeah, that's going to be coming up September 15th. Yep. It's all for charity. It's for the Yellow Brick Road Foundation, which is a great charity, a great local charity here who helps children that have congenital heart defects. So 100% of all the money is raised, not just proceeds, 100% of every dollar we raise goes to that charity and to help them. So it's going to be September 15th at Tuffy's out in Sanford. We're going to have a bunch of local comedians. We did it last year. It was a great time. Everybody seemed to really enjoy it. There'll be a bunch of local comedians who come out there. Tickets start at $15. So
Can't beat that.
Can't beat that. It's a Friday night, I believe. So if you're interested in tickets, go to Moe, M-O-E, ComedyJam.com. MoeComedyJam.com, and you can buy your tickets there, and we'll see you out there.
Yeah, I was there last year. It was a really, really, really good time. Lots of laughs.
Yeah.
Different lineup. So if you went last year, we got a few different comedians this year.
Yeah, I think everybody really enjoyed it last year, so hopefully we get a good crowd this year. We were sold out last year, so get your tickets if you want to go, because it probably will sell out again. But everybody seemed to really enjoy it, so we're doing it again and raising some money for a good charity.
Cool. So it's MoeComedyJam.com.
Yep.
All right, Moe. Well, let's talk about legal issues. You're the brains of the legal operation here on the DeWitt Law Review. So we got some legal things to talk about. Probably the most interesting thing in the last week or so is this Florida and fathers' parental rights, and there were some changes in the law recently.
Yeah, there's been a lot of changes in family law in general. We talked about the alimony law that got passed, a few weeks ago now. And how that's going to have a significant change on alimony in the state of Florida, obviously. And if you missed that show, you can always go back and listen to it on our podcast version to catch up on that. But some significant changes in the way alimony is handled in Florida, but also significant changes in the way paternity actions are handled in Florida. So, we've done whole shows on this before. Where under the old law in Florida, if you had a child with somebody, with a woman, and you guys weren't married, the father had no legal rights until you went and filed a paternity action in court. So you actually had to go file a lawsuit, basically against the mother. And a paternity action basically did two things. Number one, it legally established you as the father. And then number two, it did a parenting plan, which outlined time sharing or custody and child support. So that became problematic because you'd have couples who had kids together and maybe they're living together and getting along fine. Well, then they break up. Well, now dad doesn't have any rights, and courts are not the fastest system in the world.
They're not?
No. So, we've had cases before where parents break up, and then one parent, moves, or typically the mother, because she has the legal rights, moves across the country with the kid, and there's nothing the father can do about it legally
until it goes
paternity
to court.
Is established. Mm-hmm. Yeah. So, and even if the mother refuses to let the dad see the kid, even though the dad may have been involved in the kid's life every single day since the kid was born, once they break up, mom's mad, says, hey, can't see the kid anymore. There's nothing the dad can do about it until he gets to court. So a new law was signed by Governor DeSantis on July 1st. that has somewhat changed this. So the key distinction here is that you can now sign a document when the child is born that will establish paternity on behalf of the father. Now, hopefully, that document will be readily available to people and people will be informed about it. But obviously, if you don't sign the document, you're still in the same situation as before, where you have to go file a paternity action. But if you sign that document when the child is born, paternity is established, and so that can't happen.
And this is with unwed.
Yes.
Unwed
yeah,
mother
if you're married, there's a presumption you're the father. It's a whole different story. This is with people who are not married. That's a good key distinction there.
Okay, and so unmarried, you have a child at the onset of their life, at their birth.
Right.
You can sign this document that says mom and dad both say we are the parents.
Right.
And then we're good as long as that document is readily available.
Yeah. So I mean, our hope is that kind of as part of the birthing process, when you fill out the birth certificate, this document will be included there, and both parties can just sign it.
Can you do it later? Like, let's say a year goes by, 2 years go by, and then you say, you know what, we forgot to sign that thing at their birth. We both believe we're the parents. Let's sign this paper now.
No, you can still do it later.
Okay.
The problem becomes is just like everything else in life, you forget to do it. You kick the can down the road. So in order for it to be kind of a part of the norm, I think it would have to be offered at kind of birth, as part of that package. But once it's signed, there's a 60-day window where either party can revoke the signature, essentially. So, if something happened, you found out you're not the father or something like that, there is that 60-day clause there. After that, you'd have to file a judicial proceeding if you want to disestablish paternity or something along those lines.
So if you fast forward 5 years, 8 years, 10 years, let's say you sign that paperwork, mom and dad, father, man and woman,
right?
And 10 years go by, and now you're still not married, and you break up. You go back to that paperwork, and the parental rights are like it was if you were married, or
so you still may have to file a paternity action to have a parenting plan put in place. The difference here is there's no lag time where dad's not established as the father. So like I said before, what would happen is, okay, dad would file the paternity action, but the court wouldn't legally adjudicate him as the father for months because it just took that long to get in front of the court. Well, if the court doesn't do that, then the dad has no right to time sharing. He can't move for temporary relief to get temporary time sharing in place. And also, if the mom moves out of state, I mean, that was a big problem. Mom moves out of state, dad's got a job here in Orlando, mom's now in Tennessee. What's the dad supposed to do? So having those legal rights established, from the offset when you file that paternity action right away, kind of helps from those delays affecting the parties.
Was the whole idea to sort of put mothers and fathers on the same sort of level terrain?
Yeah, essentially, because before, I mean, it really didn't make any sense where you could even be listed as on the birth certificate as the father and have no legal rights to the child. So, the it's the same thing. The mother had acknowledged that you're the father. You're listed on the birth certificate. You think you have legal rights, only to find out when you guys break up that you have no legal rights until you go to court. So then the courts are just bogged down with having to, establish a person's legal rights as the father of the child, just because it's a procedural issue. You have to file the paperwork, then you have to get a hearing. Sometimes you have to get a DNA test done, and that can take months to do. So, when really the mother's already acknowledged it on the birth certificate. So this is just kind of streamline that process to make it easier, not only for the parents, but I think for the courts as well, so they don't have to, for lack of a better term, waste their time, having those hearings when both parties have already kind of agreed that, hey, this person is the father.
I don't know if you're going to know the answer to this, and I don't even know if this specific law discusses this, but is it the same for same-sex couples, for people that are two moms or two dads?
I would assume it would be. As long as that form is signed, it would do the same thing. I don't know that the statute specifically addresses that, but it talks in the terms of parents, so I would assume it would apply equally to either side.
So as somebody who practices family law at the DeWitt Law firm, I mean, is there certain advice you would give to clients now that this new law has been put into place?
Well, I think, for anyone out there listening who, has a child with someone who they're not married to, getting this form and signing it, I think protects both of you. The other, odd issue that came up every once in a while is you would have a father, the mother and father, and again, father was on the birth certificate, and then all of a sudden the father would die, and for inheritance and Social Security and things like that, it would create issues because the father hadn't legally been established as the biological father of the child. So, if you have a child out there with someone, you guys are not married. Again, this only applies if you're not married to the person. It's a good idea to get this form, get a copy of this form, and maybe we'll try to put it up on the website. I think that would probably be
a good idea. Yeah, because my next question was like, where is this form at?
Yeah, we'll put it on our website. We'll put it under the blog section. We'll do a little article on this and have a link to the form for you if you're interested in that. But yeah, it's a good idea to go ahead and fill this form out, get it filed, and that way you're just protecting yourself, in case something does happen. Obviously, nobody ever anticipates that you're going to break up with your spouse or the mother of your child or the father of your child. But if you do, this just kind of protects everybody.
What about the flip side? Are there any concerns that you have as a family law attorney, maybe on the mother's side, where they say, well, yeah, we did this, but now I wish I wouldn't have done this, signed this paperwork?
Well, as long as the person is actually the biological father, biological parent of the child, I don't really have any concerns. And that's why there's that 60-day window in case there are concerns regarding that. And that way they can do testing, and then you can kind of revoke the consent to the signature. But otherwise, it's no different than any other paternity action and getting paternity established. Again, it just kind of streamlines it.
How does the paternity, is it like you just give blood? Like, how does a paternity test even work? I've never had to do this, Mo.
Yeah, no, it's a DNA test. So typically you have to take a cheek swab, DNA test for the child and from the parents, and establish it that way. But again, it's a slow process. It can be a few $100s. It can be somewhat expensive, especially when everybody's acknowledging these are the parents of this child. Sometimes it seems a little silly. And sometimes people just use that to, again, delay the proceedings to prevent the parent from seeing the child. And that's really sad because, especially at certain ages, I mean, being away from one parent, for that extended period of time, for months on end, can really be detrimental to the child and detrimental to the relationship overall.
This document that you talk about, this one that mother and father have to sign, do you think there's going to be cases going forward where somebody says, you know what, I thought he was the father, or I thought I was the father at the time, and I signed it, and that was a legal contract at the time, but now I'm not so sure. And then the other side says, well, you signed it. You are the dad, or you are the mom. Well, the mom's probably pretty obvious to figure out. But the dad, you signed it, but now I'm not so sure.
Well, in those cases, there's a presumption that the people who consent to paternity are the parents. Now, you can still do a disestablishment of paternity action, and those can be kind of tricky. But essentially, that's where you thought you were the parent. You signed this. You've been taking care of the child or whatever it may be. And then later on, you have some suspicion or some reason to believe you're not. So then you do ask for a DNA test in those cases, and then the court could legally disestablish you as the parent or as the father of that child. But again, that would be a more appropriate use of the DNA testing, rather testing basically to confirm if there are concerns, rather than testing everybody when there aren't concerns, if that makes sense.
You said this law got signed on July 1.
Yeah.
Was there a big push for this? I mean, was there a big push in the family law world that said this is a good idea, or have other states done this?
Well, I don't know if other states have done it, but the way that it was working before, I would say, is a little bit archaic. Just the fact that you had two parents who had signed the birth certificate, the father had been listed on the birth certificate, been living with the child. They could have been living together 10 years, 18 years, whatever it was. And then, they break up, and all of a sudden the father or the parent has no rights. It just didn't really make any sense. And then, I can't tell you how many clients we've had who have just been extraordinarily frustrated by that delay getting in front of a judge to get them legally adjudicated as the father, just because it takes time and there's nothing you can really do about it. So it's hopefully will streamline that process and eliminate a lot of those headaches.
Well, why wouldn't the birth certificate just be that document?
Well, that's essentially what this is doing. It's basically just a secondary form to the birth certificate, in my opinion, that they're signing. And now there's a statute that says, hey, if you sign this, that legally establishes, that these are the legal parents of the child. to answer your question, the reason it didn't do it was because the statute says it didn't do it before. So they're changing that now, essentially.
All right, Mo, we got to take a quick break. If you got questions for us, send those to ask@DeWittLaw.com, and we're going to answer those questions right after we come back. Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on the show, we talk about legal issues in Florida and how they affect you. My name is John Busdecker, and I'm with attorney Moe DeWitt of the DeWitt Law Firm. If you have legal questions, we got legal answers. Send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. You can also call the DeWitt Law Firm at 1-800-DeWitt Law. Mo, how was your break?
Break was good. Got some water. Good to go.
Yeah, no coffee, no donut, no none of that?
No?
No?
Yeah, trying to be healthy here.
Okay, all right. You can drink coffee and be healthy.
That's true.
Just don't put a ton of cream and sugar in it, Mo.
That's the one that tastes the best.
You don't need all that sugar.
No, I actually drink my coffee black. So.
Really?
Yeah.
All right. I put a little bit of half and half in mine.
All right.
Here we go, Mo. We got some questions for you. Are you ready?
Let's do it.
All right. This one's from Anonymous. They didn't want to be... they didn't want their name on the radio. I understand. Here we go. What is the most effective way to protect yourself from a spouse who is emotionally, financially, mentally, psychologically, and legally abusive during the divorce process?
Well, I think preparation is probably the key to success there. So, obviously this is going to be a highly contested divorce. So you want to, before you even file the divorce, you want to be consulting with an attorney and come up with a plan, come up with a strategy, especially if there's concerns about physical abuse. If there's been physical abuse in the past, you want to talk about the options as to whether a restraining order or an injunction would be appropriate. But I think really doing some detailed planning with somebody who is familiar with these types of issues and handles them, because it's obviously going to be a very emotional process for you. So it's kind of sometimes difficult to think clearly. So sit down with an attorney who's experienced in family law, experienced with highly contested divorces, and they can kind of outline a plan for you of, okay, we're going to file on this date, but before then, we need to make sure that you have a safe place to go, that you're financially stable. What do your finances look like? What are your options there? And make sure that you're, protected as much as possible going forward. Of course, if there's children, that's going to be another concern, and you want to plan appropriately for that as well. So, divorces can get very messy. They can get very ugly. But doing some preparation, I think, can really help there.
So there's another part to this question as well. It says, if your attorney decides to withdraw from your case right before mediation, would mediation have to be rescheduled as you secure new counsel?
So there's two ways to go about that. So the first question is going to be, does the mediator that you're using have a cancellation fee? If it's within a certain amount of time, sometimes it's 48 hours, sometimes it's 7 days, the mediator may charge a cancellation fee. So in those cases, you may be better off just showing up to mediation.
By yourself or with your...
By yourself, and you don't have to agree to anything, but just showing up. If you're court ordered as well, you want to make sure you show up because you're court ordered. Now, I think it would still be a good idea to reach out to opposing counsel and say, hey, I'm getting a new attorney or I'm in search of an attorney. Could we continue the mediation and see if they would agree to do that? Because obviously it's not going to be a fruitful mediation if you don't have counsel there. It's the hardest mediations are when one party is represented by an attorney and the other side isn't, because the side that isn't represented by the attorney thinks everybody's trying to trick them, even if they're not, because they just don't have the insight or the advice and the guidance to get through the process and be informed about it. So it makes it very, very difficult to settle those cases. So, best case scenario would be continue the mediation and get an attorney and then go to mediation with the attorney, but you don't want to just not show up because you could be subject to sanctions and paying for the other side's attorney's fees. So if they don't agree to continue it, you have to show up, but you don't have to agree to anything. So the nice thing about mediation is, all you're obligated to do is show up and sit there for a little bit, and then you can walk out and not agree to anything if you don't think you're going to be able to reach an agreement.
Does that happen a lot where an attorney would just be like, I'm withdrawing from your case?
Well, usually I think it relates to financial issues. Maybe the client was supposed to pay them and didn't, or something along those lines. It could also be if there's just a disagreement about issues, between the parties. I wouldn't say that it's common, certainly. I think most attorneys don't want to leave their clients hanging or leave their clients in that situation, but I'm sure it does happen here and there for whatever reason.
All right, Mo, we got to take another quick break.
All right.
You go get that coffee.
All right.
No sugar, no cream, no donuts.
Well, you got my order. Why don't you just go get it?
Okay, I'll go get it for you. I'll run to Starbucks real quick, and then we'll be right back.
So I got a call from a guy last night who was in a pretty bad car accident. He was behind a work truck, essentially. Some items fell off the work truck, went through his windshield, smashed up his windshield, and hurt his hand really bad. So the insurance company reached out to him right after the accident, and he was at first concerned about getting his windshield fixed. I know that doesn't make a whole lot of sense, but his hand was all banged up and really needed to see a doctor about his hand, especially because he does construction work and that's kind of his livelihood. But he was concerned about getting his car fixed, getting it back on the road so he could start driving. So the insurance company sent him some paperwork, and he signed it. And the problem is that paperwork was a release. So basically, he released the at-fault party from any and all liability for a little over $400, basically, which means he can never go after them again. So he called us to see if we can help them. Unfortunately, in this case, we can't help him. He released the other side completely, and frankly, there's nothing we can do. And that's why it's always so important that you speak to an attorney before you ever sign any paperwork with the insurance company. Worst case scenario is the attorney's gonna say, yep, you're good to sign it, good to go. Worst case, or best case scenario, it'll save you from something like this. So before you ever sign a release, before you ever sign any paperwork with the insurance company, reach out to an injury attorney. Most injury attorneys won't charge you a dime to talk to you and take a look at that and try to help you with it. Unfortunately for this individual, it's a little too late, but hopefully somebody else out there can learn from his story and hopefully avoid making the same mistake he did.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on this show, we talk about legal issues in Florida and how they affect you. My name is John Bustegger. I'm with attorney Moe DeWitt of the DeWitt Law Firm. If you have legal questions, we got answers for you. Send those questions to ask@DeWittLaw. That's ask@DeWittLaw.com. You can also call the DeWitt Law Firm at 1-800-DeWitt-Law. Mo, how was your coffee?
Coffee was great.
It was good?
Yeah, I appreciate you getting that for me.
I had to hurry up and get over there and then get back here and bring it to you.
Well, you got it done. That's all that matters.
Okay, that is all that matters. So, Mo, I got more questions for you.
All
right, you ready?
Yep, let's do it.
Here we go. I heard an attorney on a different radio station.
How dare you?
I know. Said that when a child turns 18, you should take the car you bought them out of your name and have the child only on the title to protect my assets. This is the question, which I understand. Now, here's the question, though.
Yeah.
The question is, do I need to put my child on a separate insurance policy by himself so I am not involved at all? Or can he still be on my insurance that I pay for him?
So in Florida, if somebody's in a car accident, both the driver of the vehicle who is operating the vehicle, obviously, and the owner of the vehicle can be sued. So that's why they're giving the advice to put the vehicle into the minor's name, because it somewhat insulates you from a lawsuit. And I think if you remember, there was a somewhat famous case with Hulk Hogan's son where he got into a really bad accident and some sort of supercar, I think it was, and his best friend was severely injured. I think is disabled for life and had a traumatic brain injury and was in really bad shape. And then Hulk Hogan got sued. He wasn't operating the vehicle, but he owned it, so he got sued. Now, as far as the insurance part of that goes, you really have to speak to the insurance company about that. And so being on the insurance policy doesn't really open you up to liability. But of course, you want to make sure that the insurance company knows that the title has been transferred solely into his name. And then typically they'll be able to set up a policy, whether, in his name or your name, that provides for that. But just being on the insurance policy itself doesn't open yourself up to liability necessarily. It's being on the title of the vehicle. But again, and the biggest thing there is, if you're going to transfer the title of the vehicle, make sure your insurance company knows about it, because you have an obligation to tell them and update them. And if you don't, then they could deny coverage altogether. So you want to speak to them and let them know what's going on.
This person, Joe, said that the Progressive insurance agent told him that he could leave his son on the plan, but he also said, I don't trust the sales agent.
Well, yeah, that's what we're here for. Give you a second opinion. But,
all right.
But it's not so much trusting the sales agent. It's informing them of what you're doing. But again, just, however the policy is set up doesn't necessarily open you up to personal liability.
All right. Next question, Mo. This is from Greg. He's in Fort Lauderdale. Must have been driving through Orlando and heard the show, or maybe he listens to the podcast. He says he's interested to know what the Florida law says about grandparents' rights and if they can get visitation rights.
So typically the answer is no. Florida has very limited grandparents' rights, and typically grandparents have no rights in Florida. So that's kind of the short answer to that. Now, there are a few exceptions to that. There's a newer law that was passed maybe a year or two ago where if you have one parent who dies and the other parent is found to be liable for that death, then it can open up some rights to grandparents.
Like a homicide?
A homicide or somewhat related to a homicide.
Okay.
Yeah. So there's actually it's a case that happened in Tallahassee. It was a law professor at Florida State College of Law who was murdered and had two small children with his wife. And then the person who's died, his parents didn't get to see the kids anymore. And it turned out there's been a number of trials since then, but the wife's brother hired a hitman through his girlfriend, and so far the hitman had been convicted. The girlfriend was convicted. I think the brother's actually now on trial. The wife has not been charged with any crimes at this point, and I don't know that she will be charged with any crimes, but that's where this law came from, was basically the grandparents here are saying, well, look, these people may have unclean hands here in this person's death. They shouldn't be able to lock us out from not being able to see our grandchildren. And so that law, it's called the Markle Law, was passed because of that.
All right. So not so many rights if you're a grandparent.
No. I mean, typically in Florida, we get these calls every once in a while, from a grandparent who wants to establish rights somehow. But typically, unless it's that kind of case or a case where the child's been, abused, abandoned, or neglected or something along those lines, it's really difficult to establish any sort of rights in Florida.
All right. Next question, Mo. This is from Nancy. She's right here in Orlando. Can you explain how Florida lemon laws work? And what can I do if I think I got a bad car?
Oh, boy. So I don't deal with lemon laws very often, but I think there's some provision there where you have to attempt to get the vehicle repaired about 3 times or something along those lines. I'd really suggest, consulting with an attorney who does lemon laws. It's a very niche area of law, but there are some attorneys out there that's basically all they do. Mm-hmm. But you just need to follow the statute and follow those provisions so that you make sure. I think the idea is basically you're giving them the opportunity to cure the issue, but if they're not able to cure the issue, then they have to kind of make it right.
All right. And is that only new cars, or is it also used ones?
I think it mainly applies to new cars, but again, not my area of law.
All right. This is from Paul. He's in Sarasota. He says, let me see here. Oh, here we go. Wondering if there are any special considerations under Florida law for creating a will or trust as a single childless individual.
Well, I mean, I guess the first question would be, where do you want your money to go?
Yeah.
So, people can give their money to charities. You can give your money to a foundation. There's
to your dog.
You can put it. We've had cases with dog trusts before, so you can set up a trust to take care of your dog. after you're gone.
There's a famous one in Miami where that dog got that house that was like an $18 million house.
Yeah, so I wouldn't say there's any special provisions in Florida. It's just a matter of how you want to do it and how you want it set up. Now, the thing is, if you don't set something like that up and you don't have any heirs, the money escheats to the state. So it basically goes to the state of Florida.
What do they do with it?
I'm sure there's some sort of fund that they put it in or something like that. But yeah, if there's no heirs and they don't know who should go to after a certain amount of time, it goes to the state of Florida. So you're probably better off setting something up, even if it's giving it to a charity that you like or that you believe in or something along those lines, to prevent that from happening, essentially.
All right, this is from Thomas. He says he's new to Florida, and he doesn't understand how the no-fault insurance works here in Florida. What would happen if he got in an accident?
So, every once in a while, someone will send in a question or will ask me, well, how do you get cited for a ticket if this is a no-fault state, or how do you sue somebody for a car accident if this is a no-fault state? Well, no-fault insurance doesn't necessarily mean that we don't find fault in accidents. It just basically means that everybody in the state of Florida it's one of the required insurances, has up to $10,000 in PIP benefits, personal injury protection benefits, which are commonly called no-fault benefits. And what that basically does is, if you're in a car accident, whether you're at fault or not, you have up to $10,000 in benefits to go see a doctor. You don't get a check for $10,000. It's, so that you can go to the hospital, you can go to your doctor, you can go do whatever you need to do with that money to get treatment, up to $10,000 worth. That's all that really means. Now, we have that insurance in lieu of bodily injury insurance, because we're the only state in the nation where you don't have to have bodily injury coverage on your policy. So somebody can legally be out there driving and they can hit you and hurt you and not have insurance to cover you.
I think when you tell other attorneys that from other states, they're blown away.
Their minds are blown. I mean, yeah, because we talk to a lot of attorneys in other states. We're in some groups where we work with them. And nobody understands nobody understands why we don't have bodily injury coverage.
Why don't we? What's the benefit of that?
Well, the big argument to not have it is to keep insurance rates down. But when you look at other states, again, we're the only state of the nation who doesn't have a requirement for bodily injury coverage. We still have some of the highest insurance rates in the nation. So the argument doesn't really add up, in my opinion. But that's probably a conversation for another day. But, as we've talked about before, living in Florida, driving a vehicle in Florida, one of the most important coverages you can have is having uninsured motorist coverage on your policy. Because what that does is, if somebody hits you who doesn't have insurance, it's going to step into the shoes of the at-fault driver. And so that way you can make a recovery for things like lost wages and medical bills that go beyond those $10,000, and pain and suffering and everything else that comes with being in a bad car accident. So it's really good coverage to have to protect yourself, especially in Florida, just because, we don't have that bodily injury requirement. So you can legally be on the road and only have the $10,000 in no-fault benefits and $10,000 in property damage, and that's all you're required to have.
When people are going online to get their insurance, because you kind of got to do that every now and then, every 6 months or so, and sometimes it's automatically renewed. Is there any advice you give people? Like, you should probably have this much coverage, or, I know everybody's different. Everybody's cars are different. Everybody's lives are different. But is there something you're like, you should at least cover this?
Well, I always recommend having enough coverage to protect your assets. So, the whole idea behind insurance is that if somebody sues you, you want the insurance to pay out rather than them going after your assets. So you want to make sure that you have enough insurance there where they're not going to come after you personally. And we've seen that happen before, and it's not pretty. So that's the point of the insurance there. So I think sometimes when people go and they get quotes and they try to get the lowest rates possible, obviously, but they're not looking at what they're actually buying, it can be a detriment. So if you're ever looking at that, and we've done this on the show before, feel free to email us, ask@DeWittLaw.com. I'll do a free insurance review for you. Just send me over what you're looking at or what your current policy is, and we'll try to give you some advice there. But of course, the rate is important. You want to save money, but you also want to know what you're buying with that money and what your protections are.
All right, Mo, next question. I might stump you on this one.
Let's see.
You never know. Here we go. This is from Lucy. She lives in Winter Park. She said, I'd like to know if there are any specific laws in Florida regarding the use of drones and their privacy implications?
Oh, there are. So I actually was quoted in an article in Newsweek about drones a long time ago because I actually knew information about drone law then.
I'm sure it's changed, though, too.
I'm sure it's changed. Now, obviously, there's some FAA regulations regarding drones. You can't fly them near airports and things like that. Regarding privacy, certainly it would follow the same laws that cameras probably would, with invasion of privacy, peeping Tom laws, things like that, to where you can't really shouldn't be flying them into people's backyards, looking at windows, things along those lines.
But you see those beautiful shots that people shoot, like going over the road or going over like downtown, and is that the same as being in somebody's backyard? Because you can usually see their backyard, but are you specifically trying to get into their window?
Well, of course, it depends on the intent, and it depends on whether there's an expectation of privacy. So there was a case a little while ago where there was a neighbor who put a camera on like a 17-foot pole on his roof aiming into the neighbor's backyard. And the court finally entered an injunction saying that's an invasion of privacy. Obviously, there's no legitimate they claimed it was for security. And the court said, no, there's no legitimate purpose to have it up that high so that you can see into their backyard. So I think it's going to depend somewhat on intent, whether it's permissible or not in those kinds of cases. But you also have to be careful with drones if you're using them for commercial purposes, because there was a guy who I think he was doing a drone video of the University of Virginia, if I'm correct, and he didn't have the proper license to do it for commercial purposes. And I think the FAA hit him with like a $20,000 fine or a $50,000 fine, something pretty significant. I can't remember what happened with that case. I think he might have had to pay it.
There are some rules, and there's certain heights, like I think you're allowed to go up to, and you're not allowed to go up to, and you're right about the commercial stuff too.
Yeah, because you want to stay out of airspace, obviously, with airplanes. So I think you have to keep them under 500 feet. I don't own a drone or a drone license, as you may be able to tell. But yeah, there's all kinds of drone laws, so you do want to be knowledgeable of those. If you have a drone, if you own a drone, you're supposed to have a drone license, so you should do that. And then, of course, if you're using it for commercial purposes, you have to have a different license. So be careful with that.
All right, next question, Mo. We got about a minute left here. This is from Steve. He lives in Ocoee. He said, "Can you explain the liability I have if my pet injures someone?"
You're liable.
Okay, all right.
I mean, typically there are some exceptions to it. If somebody's breaking into your property, that's an exception. If they're trespassing on your property, that can be an exception depending on the rules. Or the circumstances rather, but typically especially if your pet is off leash, if it's not being controlled, and it injures somebody else, you can be liable for that.
What if like two dogs are sort of getting in a fight and you're trying to break it up, and your dog bites the person, but it was caused by the fight? Like I just feel like there's a lot that can happen with animals.
Well, that's why your dog's supposed to be on a leash. So
okay,
typically
good
there's
call.
leash laws to kind of help prevent that.
All right, Mo, we're gonna take a break. Don't go anywhere. We're going to keep answering your questions. Just send those questions to ask@DeWittLaw.com. We'll be right back.
All right, the crash happened. I was at a stop. The car was coming in, rear-ended me from behind. I was trying to get out of the way, but yeah, that didn't happen. Yeah. After the crash, I just kind of sat down for a couple minutes, gathered my thoughts, after the ambulance and stuff. Got discharged, went home. I was really trying to think about what to do next, because that was my first accident. Of course, you hear all the time, call an attorney, so I wasn't really sure what route. I reached out to a friend of mine, and she was just like, hey, I have someone you can reach out to. And she said, just call Mo.
Many of our clients are referred to us by friends and family, just like in Jamal's case. It was an honor to be able to represent him and ultimately fight to get him the compensation that he deserved.
My experience with Mo was really good. His team, his staff, very informative. I received all the information I needed, step by step. They made sure I was satisfied with everything, and everything has been really good. They're very detailed. They're very, they call or text whenever they make a move or whatever they're doing. They're mailing out a letter, anything. I'm always in the know. So that's really good on their part. So yeah, if a friend or family member, anyone would ever ask me if they need an attorney, I'll always say, just call Mo.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on the show, we talk about legal issues in Florida and how they affect you. My name is John Busdecker. Right across from me is attorney Moe DeWitt of the DeWitt Law Firm. If you got questions, we got answers. Send those questions to ask@dewittlaw.com. That's ask@dewittlaw.com. Mo, are you ready for some more questions?
Absolutely. I should say you can also leave us a voicemail
Okay.
at 407-53-MOSES, 407-536-6737. Sometimes that's easier for people, so feel free to give us a call and leave a voicemail there.
You own a lot of phone numbers, Mo.
We do, actually. Yeah.
Okay. just throwing that out there. All right, here we go, Mo. Next question. We got a few minutes left here. This is from Allison. She lives in Vero Beach. What is the process and the grounds for getting a restraining order in Florida?
Well, it depends. She asked the grounds, so it depends what the grounds are. There's a few different types of injunctions. One is for stalking. One is for violence, essentially. Those are kind of the two categories that they fall in. And so the biggest mistake people make with injunctions is they wait too long in order to apply for them. So, if there was abuse, a year or two ago, and now you want to get an injunction, typically it's too late. The violence usually has to be pretty immediate. And obviously they do that because they don't want people using injunctions as a form of retaliation. So, the process is essentially you usually go down to your local courthouse in whatever county you're in. If you ask them, they usually have an area dedicated to injunctions where you get the paperwork, and you have to fill out some paperwork basically asking or stating, why you're applying for the injunction and what happened and when. And the most important thing when you're applying for an injunction is to be very detailed as far as when the allegations occurred and how they occurred. A lot of people want to tell their life story in that, and sometimes it gets lost. Really what you're trying to show is that you have an immediate threat of being the victim of domestic violence or have been the victim of domestic violence. And so you need to outline in that paperwork that's what's going on, and that's why you need the injunction. Now, I mentioned there's also a stalking injunction. Those are a little bit more difficult to get, but again, you want to be very detailed in the allegations as far as the stalking that's alleged to have occurred.
All right, Mo. Next question. This is from Beth. She's in Titusville.
Okay.
She is asking, can you explain how Florida laws deal with fraudulent activities online and cyberbullying? I know those are sort of separate, I think, but let's stick to the cyberbullying. How does Florida law, how does it deal with cyberbullying online?
Well, I think we did get a cyberbullying statute in Florida a little while ago.
Or just online harassment. I mean, I guess they're kind of the same thing.
I mean, you could apply for a stalking injunction.
Really?
There is cyber stalking as part of the stalking injunction. So that is one, leading back into the last question, that is one route that you can take.
Does the other person have to be in Florida? I mean, what if they're somewhere else?
Well, arguably they submitted themselves to jurisdiction by harassing you here in Florida. Personally, I've never had that case. Usually it's two people who are in the state because they're in a relationship or, they know each other or are acquaintances or something along those lines. But cyber stalking is included in the stalking injunction statute. So that could be one option, as well as I believe there was a cyberbullying law passed a few years back. So you could take a look at that and see if that offers any remedies for you there.
All right, Mo, this is going to be the last question of the day. You ready?
Let's do it.
It's from Laura. She's in Kissimmee. Can you clarify the differences between legal separation, divorce, and annulment under Florida law?
So one misnomer is we really don't have legal separation in Florida. You're either married or you're divorced. So a lot of people think there's a legal separation, and some states do have that, but here in Florida we don't. So you can be separated, but you're still legally married until you get divorced. And until you file for divorce, there's really nothing the courts can do for you, because by filing for divorce is what gives you basically access to the courts. Now, there is a basis to get marriages annulled if they were entered into, for fraud or things like that. We've dealt with those cases before, but they're pretty rare, frankly. So, an annulment is basically you're trying to show that the marriage was never valid, as a divorce is obviously where you're dissolving the marriage.
All right, Mo, we gotta go. That
All right.
that hour goes by fast.
It goes by quick.
Sure does. So don't forget, get some tickets to our Just Call Moe Comedy Jam, September 15th at Tuffy's in Sanford. Just go to moecomedijam.com. Tickets are only $15. It's a deal.
Yeah. It's all for charity and should be a great time.
All right. We will see everybody next week. And don't forget to send those questions to ask@DeWittLaw.com.